Okay, I think everyone should be able to see us, hear us. Thank you. Welcome to everyone today. So for today's webinar, we're doing, it's going to be all about probate and how to avoid it. My name is Beth Cohen-King, and I'm the Director of Marketing at Margolis and Bloom. So today we have Tricia D'Agostino. She's a partner at M&B, and she's going to dig deep into all things probate. What is it, and what do you need to do to avoid it? Tricia practices in the following areas of estate and long-term care planning, mass health applications and appeals, planning for children with special needs, settlement planning, guardianship and conservatorship, and probate administration. So Tricia has developed a specialized practice in the area of advising clients how to supplement the cost of care at home or an assisted living facility through the use of a myriad of mass health, veterans, and low-income programs. That's just a little bit of her bio, but you can read the full bio at margolisbloom.com under the attorneys section. So please feel free to ask questions in the question panel, and we will incorporate them into the discussion or address right afterwards. And for some reason, if you do need to jump off, we are recording the presentation. So with that, let's begin.
All right, thanks, Beth, and thanks everybody for joining us today for an hour to talk about probate. Not a super exciting topic, but hopefully you'll get something out of the presentation. So as Beth said, we're just going to talk a little bit about what probate is so it's clear, because I think people often hear the word probate and they know they want to avoid probate, but they don't really know what probate means. So I'm hoping to clarify that for you today. And this is just a bit about how we're going to structure the presentation. So first, I'll go through the definition of probate so that you know what it is. And then we'll talk about when you actually have to go through with the probate process, what assets are probate assets versus non-probate assets, and then what happens if there's real estate in the probate estate. That complicates things a little bit, and so I'm going to talk a bit about that. And then I'll also talk about how to avoid probate, because once we go through the process, it's likely you will want to avoid it, and different types of trusts that we use to do that. And at the end, I'll just finish up with some essential estate planning tools that everybody should have, both to avoid probate and also to avoid additional legal expenses that could be incurred during life if you have to go to court to get authority to make certain decisions and things. So let's get started. And so first is what is probate. So the process of probate is going to court to get a personal representative appointed to manage an estate that used to be called an executor, or to get a will allowed. In some cases there's a will, in some cases there isn't. But if there is a will, in order to get it allowed, you have to go through a probate process. And the personal representative would be the person who would make decisions, manage the estate, pay taxes, file final income tax returns, and ultimately distribute the property out to the beneficiaries. The will is the document that says where the assets will go. So who's going to actually get the person's assets, and neither of those things can be done without actually going to court, following a process, and getting a judge to issue a decree that, one, the will is valid and was legally executed, and that the personal representative appointed is the one who has priority of appointment, either through the will or under the law. So that's the process that people try to avoid if possible, and the reason is that it takes a lot of time and it's expensive. So you have to hire a lawyer to do it. You don't have to, you could do it on your own, but most people do choose to engage an attorney because it is a little bit of a cumbersome process. And what happens is there's two different ways to file it. You can either file an informal probate, or you can file a formal probate. A formal probate I usually use for situations when there's real property, so any real estate that's in the probate estate, or if there's any issue at all with beneficiaries, maybe contesting the will, families that don't get along necessarily, any reason why I would want it, a court supervising the entire process. I'd go for the formal probate versus informal. Informal I'd use in cases where you just have typical family situation, the assets are going equally to the children or all to the husband, there's no real estate involved. I'd try to go the informal route. The difference between the two is the length of time that it takes to go through. So with the informal probate, once you file everything with the court, so the petition to appoint the personal representative, a petition to allow a will if there is one, If you do that informally, you should be able to seek allowance within 7 days after giving notice to the interested parties. So it's designed to be quicker than the formal, which isn't allowed until a citation is issued by the court after you file everything. There's a 30-day waiting period before you can even file to get it allowed. And after that, there'll be a hearing to determine whether or not there've been any objections made or anybody's objecting to the person being appointed or objecting to the allowance of the will. That's the point of that notice period in either case, is to basically notice all the interested parties and say, hey, I'm trying to file this will. This was my mother's last will and testament dated X date. We're seeking allowance, and I've noticed all the heirs at law, all the children and anybody named in the document. That gives them the opportunity to object, to come forward and say for one reason or another that should not be allowed. Assuming nobody objects to the petition, the judge will then issue a decree authorizing the appointment of the personal representative and the allowance of the will. That process can be further complicated, obviously. If someone does contest, then you're in this position where it could go on for a very long time, because there's a debate about whether the personal representative should even be appointed, or there's a debate about whether this will is the last will, whether there might be one that was executed after the fact, giving property to other people. That can certainly delay the process and take a longer time to go through. Additionally, even things that aren't controversial like that can cause delays. So, for example, if you have one spouse dies and the other spouse is incapacitated, they have Alzheimer's disease, in that case, a judge might appoint what's called a guardian ad litem to represent the incapacitated spouse to make sure that the will and the appointment of the personal PR that's being sought are the right thing, and that somebody's looking out for their interests. That can delay things and also cost more money. That's another lawyer being paid to represent someone's interests. So as you can see just from that brief description, the process is time consuming, can be more so depending on the circumstances. It doesn't necessarily have to be controversial in order for it to be time consuming. It can just really be ordinary course of events. But once that whole process is complete, if it's a standard situation, no objections, it's an informal probate, you should be able to get somebody appointed to manage the estate and have access to assets within a couple of months. That has not been the case during the pandemic because the courts have all been really backed up. So it's taking many months for things to go through just because there aren't a lot of people in the courts to process it. But in normal circumstances, I would say a couple of months for an informal probate to go through. And for a formal probate to go through that isn't contested in any way, you don't have to have guardian ad litem appointed to represent minors or incapacitated beneficiaries. You could probably see that go through within 3 to 4 months. And the reason it's important the reason we care about how long it takes is, in practice, if there are probate assets, that means that in order to get access to them, this process has to be complete. So the personal representative cannot access a probate asset like a bank account to pay bills on behalf of the estate until they're appointed by the court. So that's why we care about how long it actually takes for this to go through, and why you're trying to avoid that, because when someone passes away, you might have to pay an estate tax within a certain period of time. You want to pay a lawyer to hire them to help you through all this, and any other thing that has to happen, like estate tax returns and things like that. You want to pay bills, like if there's a mortgage or whatever the case is, you want access to assets. And until this process is complete and the personal representative is appointed, you have no access.
Trisha, I just have a couple of questions here, just fast ones. So do you have to go through probate if you have a will?
So that's interesting you should say that, because that's my next slide. So I'll talk about that in 1 second. Is there anything else, Beth?
Yeah, someone said they missed the time period for the informal probate process.
So you can, you have to wait 30 days from the day someone passes away to file anything, either formal or informal. And once that period comes, you can file the informal with the probate court. You have to give notice of that filing within 7 days to the interested parties, and after that you can seek allowance. But that means that just because it says you can get it allowed within 7 days of filing it after you give notice, it takes time for the court to process all of that. And when they get to it, and depending on how backed up they are, but I would say in normal circumstances, it's about 2 months. In COVID, it has been much longer than that. It took like 8 months for one of our probates to go through just because it got lost in the shuffle. There's no way to follow up with the courts really because we couldn't go in. So you don't want to be in the situation where you're dealing with it if you don't have to, because you never know what the circumstances will be at that time. Were there any more questions?
Nope, that's it for right now. I'll come back.
So I'm glad you said that. Do I have to probate if I have a will? Because that's my next slide, and that is literally every question, what everybody says when they come in to see us. So we talk about, okay, let's talk about some estate planning goals, tax avoidance, probate avoidance, maybe Medicaid planning. And they say, oh, well, I don't need to worry about the probate avoidance piece because I've already done a will. I have a will, a healthcare proxy, power of attorney, so I should be all set. And that's not the case. The will is the document that actually gets probated. It's not, doesn't avoid probate. So what the way you determine if you need probate is actually how the assets are owned, not whether or not you have a will. And so what assets are probate versus non-probate assets is what you're going to look at. And if you have probate assets, then you know you need to take your will to a lawyer, and the lawyer has to file it with the court to get allowed in order for the person to be appointed. So people think they have a will. I've not nominated my best friend as my personal representative, so I'm good. But the judge has to review that will, has to put it through all those motions of notice to all the people listed in the will, to all the interested parties, to make sure there's nobody who's going to contest that will. And then the judge has to decree that it's allowed before they have access. So what assets are probate versus non-probate assets? So joint assets, which are assets that are jointly owned. So if you jointly own your home with your spouse, or you have a joint bank account with your child, those will be non-probate assets. They will pass automatically to the joint owner when the first person passes away. But then they'll become probate assets, because at that point, they'd be in the survivor's name alone. So if my husband and I own our home, if I die first, he inherits my house, no probate. But then when he dies, now that house is in his name alone with no beneficiaries, and that house is probate. Assets with the beneficiary designation will be non-probate assets as long as there is a beneficiary listed. So retirement accounts, life insurance, sometimes stock accounts, transfer on death accounts. Sometimes you see TOD or POD, that's pay on death. That means when the person passes away, it will automatically go to the person listed as the POD or the TOD or the beneficiary. So for my 401k, I have my husband listed, and then I have my trust for my kids listed as the second beneficiary. So you always want to make sure your beneficiary designations are up to date. Check with your employer to make sure that they have them on file. Make sure you have them on file. Make sure you have both a primary beneficiary listed and a contingent beneficiary. Because if something happens to your primary, your first thing is that you think of is not going to be, oh, let me update my beneficiary designations. You may not even think of that. So just make sure you double check those things. That's an easy way to avoid probate, because the assets will automatically pass to that person. That's also important to know in conjunction with the will question. Like, I have a will, so I don't have to probate. If your beneficiaries under your will are one group of people or one person, and your beneficiaries of your retirement account is someone else, whatever the beneficiary is that's listed on the asset is where it will go. It doesn't matter what your will says. The will only governs probate assets, which are assets in a person's name alone that do not have a beneficiary listed. So that's another important part of estate planning, where you want to make sure your beneficiary designations line up with your will, and that you know, maybe you do want them to be different people. Maybe you want one person to receive your IRA and someone else to receive everything else. But just make sure you're thinking about that and it's done with purpose and isn't it's not an accident and assets go to the wrong place, thinking that the will might govern those assets that beneficiary designations do.
I'm going to jump in again because this is related, and maybe you just answered this, but just to clarify. So one of the questions is, if most of the assets are in IRAs and TOD investment accounts, TODI, can those be transferred to beneficiaries without going through probate? Is there some minimum dollar value outside of the assets above the required probate?
So whoever the beneficiary is that's listed on any asset is who will receive it, and there will not be a probate required for those assets, as long as there's a beneficiary listed or a TOD or POD. And if there's some checking account that you have that has $15,000 in it that doesn't have a beneficiary listed, because we can't list beneficiaries on our checking accounts, right? So our little savings accounts at Citizens Bank or a checking account that used to pay bills, that's just going to be in your name alone. If that account is under $25,000 when you pass away, you can go through a very simple probate process, which is called the Voluntary Administration. And you pay a filing fee of about $150, I think it is. You fill out a form that says the decedent's name, date of death, file the death certificate, say who their heirs at law are. There's no notice requirements to those individuals at all. You just file that with the will, if there is a will, and the death certificate with the probate court, and they will allow that, and that gets you access to anything under $25,000.
Okay, another one. Does direct beneficiary of mutual funds avoid probate and access is immediate?
Yes. So it does, yes and yes. So it does avoid probate as long as you have a beneficiary listed on the account, and access is immediate, except for the fact that you do have the beneficiary has to jump through the hoops that the financial institution requires. So for example, you are named as beneficiary of your father's IRA with Fidelity. He passes away. You send the death certificate to Fidelity. They then send you a letter to say, oh, you were named as beneficiary. We've been noticed that your father passed away. We're sorry to hear this news. Enclosed as a beneficiary. You were the beneficiary, enclosed are the forms for you to file a claim on this. You can either roll it over and open an account here, or you want to take a lump sum, or whatever their options are. So there's some time that you have to go through the motions of filing paperwork and so on and sending it in, but they'll have access relatively quickly, much more quickly than they would if it was a probate asset.
Okay, and then another follow-up here. What if your house is in a revocable trust with yourself and your children? Will your house automatically go to your two children?
Yeah, so assets in trust, that's another great question, because that's the next thing on the list. A trust is another really great way to avoid probate. So if you put your home in a revocable trust, which it sounds like is this question, the trustee may be yourself, and then maybe your child is your backup trustee or your friend, and then there's a whole list of beneficiaries in the trust under the terms. You're in charge of the trust during your life. When you pass away, the successor trustee automatically steps in, and then they can do whatever they want with the assets, meaning not whatever they want, but they have full access to the assets to distribute them out to the beneficiaries or pay bills on behalf of the estate or anything without going through probate. Trust assets do not go through probate.
Okay.
But I think it's important to say it's the same thing as like I have a will, so I don't have to probate. I did a will and a revocable trust, so I don't have to probate. It all comes down to how the assets are owned. So you might have a very nice estate planning package, and the documents are beautiful and they're great and they're legal. But if you haven't taken the step to follow through with your asset fund, with funding the trust, naming the trust as a beneficiary or transferring the house to the trust, it will not avoid probate. So you need to make sure both the estate plan is done and the trust funding and beneficiary designations have been updated appropriately, and your lawyer should help you with that.
Okay. And then are assets of a grantor trust included in mass probate if property is located out of state?
So no. So if you have a trust in Massachusetts and you deed your New Hampshire property into it, which we recommend doing quite a bit, then there's no probate on those assets because they're in trust. So you don't have to file a probate in New Hampshire. The opposite is true, which is why it's important if you have property outside of the state to do a revocable trust and get everything in there. Because if I've worked with my estate planner in Massachusetts, I've done my beneficiary designations, my house in Mass is in the trust, and I forgot to tell them or have done nothing with my Florida residence, and that's still in my name alone. When I die, in order to get access to that Florida property, you have to actually file a primary probate in Massachusetts, and then I have to hire a lawyer in Florida to file what's called an ancillary probate. So it sort of doubles the cost, where you could have hired a lawyer to draft a deed in Florida for $500 into the trust and avoided that whole thing, which is tens of thousands of dollars basically in probate. So you can definitely avoid probate by putting out-of-state property in trust, but you do have to take the steps to do that. Again, the will, like I put everything in my trust through the will, isn't enough. You have to do a deed.
Okay, and I think this would probably go back into either putting things in trusts or just defining it, but does a person's personal property, household goods, jewelry, etc. need to go through probate?
No, not typically. So typically not, unless it's of a lot of value and it might be like a contested item. Usually it does not. Typically the will says something like, I give all my tangible property to my spouse or to the following group of people in as equal shares as possible. And then it's the personal representative's job to divvy that up and be fair about how they do that based on the terms of the will.
Okay, so that's where we are right now. I'll let you keep going and I'll jump back in when
Okay.
more.
So probate, the big question is probate, how the assets are owned and who the beneficiaries are. Doesn't matter what your estate plan says for purposes of whether there's a probate. So we've gone through these, but joint assets, non-probate when the first person dies, but when the survivor dies, there will be, because now it's in their name alone. The big takeaway is what will be probated is really an asset in your name alone that has no beneficiary listed. Everything else is not, including assets in trust or non-probated. All right, and I mentioned this earlier. So what happens if there's some real estate in a person's name alone? If it's in their name alone and they have a will, which ultimately goes through that whole process I outlined at the beginning where a personal representative is appointed, the will is allowed, then the person, and as long as the will says that the personal representative has authority to sell real estate, then the personal representative can sell the property to, a buyer or whatever, to whoever is they want to sell it to. The issue is if a person owns their home alone and does not have a will, then you have to go through some extra hoops with court, and it's not ideal because it's because of the timing. So if you pass away with no will, someone steps up to get appointed as personal representative with the court. They go through that whole process that takes a few months. They get appointed. It may take 6 months because this is a real estate situation, so we're going to do formal. They're appointed as personal representative and they want to sell the house. They can't sell it unless they go to court to get a license, what's called a license to sell, which they have to file a petition to the court, show the offer that has come in from a buyer, and ask the court to allow it, basically, for the price that they're trying to sell it for. The reason it's not ideal is, one, it's more time with a lawyer in court trying to get access to do things that they should already, the personal representative should already have the right to do under a will, if the person had signed one. But also the timing isn't great because you can't file for a petition to sell real estate until you have an offer. And as you may know, when you get an offer, you want to sign the offer, you want to set a closing date pretty quickly within 30 days, typically when you execute the purchase and sale, and you want to be able to capture that sale. You don't want to lose it. Sometimes it's going to take longer than that 30-day period to get this authority through the court. So it's just one more loop. If you have a home in your name alone, at least make sure you have a will that gives the personal representative the right to sell. It will still have to go through probate, but then we won't have to have this extra hoop of a petition for license to sell as well. And if you have a home in your name alone, it's probably best that it's in some sort of trust, depending on your circumstances, would depend on what trust is right for you, whether it's a revocable or irrevocable. And I'll talk a little bit about those differences. But bottom line, if you own a home in your name alone, at least have a will giving the PR the right to sell, and consider a trust to just avoid the probate process altogether so you have no title issues. All right, so here we go, how we're going to avoid probate. And so, as I said before, jointly owned assets do avoid probate when the first person passes, but it's almost only temporary because when the survivor passes, there will be probates. We want to try to avoid probate on those altogether, so we don't have to remember to do it when this first person dies. Just do something, put it in trust or something while they're both alive even, so that there's no probate. Make sure beneficiary designations are up to date. That's an easy one. You can just reach out to your employer, to your HR department, make sure that you have a primary contingent beneficiary listed on everything. If you have a financial advisor, check in with them. Make sure your life insurance is all up to date. And you have your beneficiaries listed. That's an easy way to avoid all this cost. And then through the use of trusts. Anything in a trust will avoid probate upon passing. So there's different types of trusts. So one of the most common to avoid probate is a revocable living trust. With a revocable trust, you can change it whenever you want. You can be the trustee, you can be the beneficiary. So you're not giving up any control. You're just changing the name of the account essentially. So it would be, instead of being in a bank account in the name of Patricia D'Agostino, it's in the bank account in the name of the Patricia D'Agostino Trust, with Patricia D'Agostino as trustee and her as beneficiary. So I have full access, full control. I can trade on the accounts if I want to. I can sell real estate. I can withdraw all the money and use it for myself. But when I pass away, the successor trustee that I have named can step in and use the assets for the beneficiaries, or pay lawyers, or pay estate taxes, and then ultimately distribute the assets as the trust dictates. And you can use the trust not just to avoid both probate, but also to kind of control the assets a little bit after you pass away. For example, I have minor kids. They're 8 and 10. So if I were to pass away, I would not want them to receive all my life insurance. I want that there for their lifetime. That's why we have it. So I would have my brother-in-law be the trustee, and he would be able to use the money for the kids for whatever he thinks is appropriate. And then when they reach certain ages, like I think I have half at 30 and half at 35, the kids can demand half at those ages, but all in between, the trustee can use it for whatever they need. And you can do anything like that. With the trust is much more flexible than a will that way, where you don't just terminate when the person passes and distribute everything out necessarily. You can choose to put some controls over the assets if you want to. Of course, you can say upon my death, everything is split in equal shares and goes to the following people too. But it just gives that opportunity, as well as to avoid probate, the opportunity to control assets too. People sometimes use what are called realty trusts for real estate, and we don't use those so much anymore because a realty trust gets recorded with the Registry of Deeds, but this what's called the Schedule of Beneficiaries, which says who the beneficiaries are when the person passes away, or actually who the beneficiaries are, period, is not recorded and often gets lost. So if someone comes in and they say they have a deed, their home to the Smith Realty Trust, and where the deed's there, we have a copy of the Smith Realty Trust because it was recorded. I don't know who the beneficiaries of the trust are because they lost that Schedule of Beneficiaries, which is the last page. So instead of using those, I typically just use a regular revocable trust for real estate instead. So a revocable trust can hold real estate, it can hold stock accounts, it can hold a bank account. And the way you actually put things into those accounts are really just into the trust, rather, just if it's a piece of real estate, you would do a deed to transfer to the trust, and that's it. If you have a stock account that you want to transfer into the trust to avoid probate, you would open an account in the name of the trust and transfer the funds in. But the accounts with a revocable trust are all still with your own social security number. You don't need a new tax ID number, no new trust tax filing or anything like that. With a revocable trust, it's still all in your social. So it doesn't complicate matters aside from the paperwork you need to fill out in order to open the accounts. We also use what are called revocable credit shelter trusts. That's for couples who might have a taxable estate. And in Massachusetts, the estate tax threshold is $1 million. So if you have more than that when you pass away, you'll owe Massachusetts estate tax. And that does go back to the first dollar once you're over. You can leave a couple, if one spouse passes, they can leave their surviving spouse an unlimited amount of money, and there's no estate tax at that time. The estate tax is when the surviving spouse dies. But because if I pass away and leave my husband all of my assets, there's no estate tax for him at that time. But when he dies, he only gets to exclude 1 million. And instead I gave up my 1 million. So really 2 million in a couple should be tax free. So that's what we use revocable credit shelter trust to accomplish. It's kind of convoluted, but in essence, you can use revocable trust for couples to allow them to pass 2 million versus 1 million estate tax free in Massachusetts. That's the current law. That number could change. And then it can also minimize federal taxes as well. Federally, the estate tax threshold is about 11.7 million each right now. So So it just depends on where you are, but the revocable credit shelter trusts are both to avoid probate and to minimize taxes. And then irrevocable trusts are also will also avoid probate if the assets are transferred to them. And those are designed more around people who want to gift assets and get them out of their estate. So they might create an irrevocable trust for their children and put a chunk of money in there. That avoids probate. It also reduces the size of the estate for estate tax purposes. People also use irrevocable trusts for Medicaid planning, for mass health planning. That's if someone needs a nursing home and they're trying to protect their property from a lien if they go on mass health. They might put their house into an irrevocable trust. And then 5 years after doing that, it can't be liened. So depending on the circumstances, we look at a client's situation in total and figure out what the best plan is. But there's a whole host of different trusts. This is only a few here. But depending on the circumstances, would figure out the right trust for you to both avoid probate and maybe accomplish some of these other planning goals as well, like mass health protection or estate tax minimization, planning for minor children, or even planning for disabled children too. So we want to make sure their assets are in trust also.
Patricia, I have a lot of questions that have come in, some relevant to this. So let me just hold on. Well, I'll just start where where the last one came in. Some are more than others. But so what is considered a reasonable salary for performing the duties of a personal representative for my mom's estate in Massachusetts? How is it computed?
That's a good question. So we don't have a statutory amount. Some states do have a statutory amount that says this is what a personal representative should be compensated. We don't have that. And so we usually tell people to keep track of their time. It's all based on how much time you're spending and bill that way. And ultimately, it's whether the beneficiaries contest the amount that you're going to take or a judge contests it. So I talked about the beginning of the probate process at first and how you get a will allowed and how you get a personal representative appointed. But after all that is done, before you close out an estate, there's a whole closing process as well. And that's when you file a first and final account showing the date of death value of all the assets, all the income that's come in, all of the expenses that have gone out, including the final distributions, and you send it to all the beneficiaries for their review, an objection or approval. You file it with the court. A judge has a hearing on it to review and approve it, and that would be where the personal representative's fees are reported, and that would be where beneficiaries have the opportunity to contest something. So whatever it is you are going to charge, make sure that you have a time log to show how much time you've spent and it seems justified.
Okay, so I'm going to just keep going. If the personal representative lives out of state, can a will beneficiary in Mass request to be appointed personal rep?
If the personal representative who's nominated in the will lives out of state, can someone else who's in state take over, basically?
I think so. I think that's what they're saying. Yeah.
Is that right?
Yeah. Can a will beneficiary in Mass request? So another beneficiary, yes, a beneficiary versus the personal representative, can they request to be changed to a personal rep?
Yeah, so there's a statutory limitation, there's an order of priority in the statute as to who can be personal representative. The first order of priority goes to the person who's nominated in the will, and then if there is no will, it goes down the family line, like a spouse, another child, etc. So, however, if you have somebody who's appointed, like sometimes we have a wife who's appointed and she's elderly and doesn't want to do the personal representative's job and isn't capable of doing that, as long as she signs, the person who is nominated agrees, they can sign a renunciation, and then they can also sign a nomination nominating the new person, and that's what you would want to do in order to get it allowed. So if the person doesn't have priority of appointment when you're filing the petition, you have to file some documents to show why they do. So whether someone's resigning or refusing to serve, or if it's a contested case, why the person with priority shouldn't be the PR.
Okay. So again, these are sort of with different topics. So I'm sorry, I'm jumping around. But if a timeshare has no beneficiary, are children required to inherit and pay maintenance fees?
I don't know the answer to that. I think that it would be dependent on what the timeshare documentation says.
Okay.
So I don't know if they could just turn it back in or sell it or how that works. But you check with the person who, they check with the timeshare, check it with the person who manages the timeshare, in other words, or the contract that you signed.
Yeah. Okay, if one spouse owns a property separately, should it still be placed under the family trust, or can the spouse have a separate trust for the property owned?
It shouldn't, I don't want to confuse you to say there should always just be one like joint trust that holds everything. It really depends on each family's situation. So sometimes there is a piece of property that is in one spouse's name that they want to keep that way, and then they might want to control beyond their death. So they might want to say, my surviving spouse has rights to use it, but when she passes away, it all goes to my family or something like that. Maybe it was an inherited property, Cape Cod home that's been in your family for years or something. We would customize a trust for that. The purpose of there's all sorts of trusts, and we can do all sorts of terms, but just a trust in general will avoid probate, but you don't have to use the same, doesn't have to be the same one for all assets.
Okay, and then what are the downsides of having your home in a trust, such as no longer qualifying for homestead declaration or the residential exemption as an owner occupier?
So, and with a revocable trust, you still qualify for the declaration of homestead. There's a different homestead declaration that you have to file. It's a homestead declaration for homes owned by trusts, which the lawyer who drafts your trust and deed to the trust would do as well, just to maintain that protection. And also with a residential real estate exemption, if you have a revocable trust where you're trustee and also beneficiary, you'll also maintain that. You just have to show the city the trust and explain to them why it's still your property in essence, and you should still get the exemption. That's not the case if you put your house in an irrevocable trust. You're no longer the trustee, you're doing it for Medicaid planning purposes. In that case, you might lose the residential exemption.
Okay, and then does a revocable trust automatically become irrevocable once the owners of the trust die?
Usually, yes. So usually it's revocable during your life, and if it's a joint trust, maybe it's revocable during either life of the two grantors, but when both of them die or when one person dies, the one grantor dies of a single revocable trust, then it becomes irrevocable.
Okay. So there's more. So I'm just going to take a break now so you can keep going, and then we can revisit some of these.
Okay. All right. And I don't have too much more of this final slide, actually, which is, we've talked a lot about probate avoidance. I hope I clarified a little bit about what it is. Primarily, it's that you want to set up trust, you want to set up beneficiary designations, you want to be thoughtful about how all of your assets are owned so you avoid probate, because it's a waste of time. You can't get access to the assets if the person needs to potentially. You're paying lawyers for something that could have been avoided, and is a lot more expensive than doing an estate plan. But there's also just generally some essential estate planning tools that you should have in place aside from worrying about probate, because you could end up in court for authority for other things as well during your lifetime. So that would be the healthcare proxy and the durable power of attorney. So a healthcare proxy is nominating someone to make your medical decisions for you if you can't. And a durable power of attorney is giving someone the authority to pay your bills, sell your home, change beneficiary designations, make gifts to anyone, including themselves. It's typically a very broad authority granted to the person that you name as your attorney in fact over your finances. And those two documents come into play if you're alive and you can't do those things on your own. So you've nominated someone to do them. If you do not have those documents in place and you become incapacitated, someone has to go to court, again, hire a lawyer like me, go to court and go through a whole process to get appointed to make decisions. And it's time consuming, just like the probate process is. And also costs money. So someone's paying lawyers by the hour to go into court to get authority to access your bank account. And just because you're married to someone doesn't mean that they automatically get to make your healthcare decisions. They have to go to court to get authority to do that if you haven't signed a healthcare proxy giving them that right. They also can't automatically get access to your accounts that are in your name alone. Now, maybe some of the accounts are in joint names, but their name is not on your 401k or your IRA. And if they needed to access that account to pay your medical bills or pay the mortgage or whatever, they can't do that, again, without going to court to get authority. So very basic. The healthcare proxy is free. We do a more in-depth healthcare proxy, and you would do that with any lawyer you went to, but Massachusetts has a state form that is free that you can download. If you Google Massachusetts healthcare proxy form, you just need to sign it in front of 2 witnesses. So do that if you haven't. And then the power of attorney, you typically use a lawyer to do, but these aren't overly complex documents and not expensive. And the process that you have to go through to get someone appointed as a conservator, if you don't have this document, is much, much, much more expensive. So definitely get those things taken care of if you haven't. The will, as I said, won't avoid probate. It's the document that gets probated, but it's important to have. You have to do one to say who's going to be your personal representative, who do you want to be in charge, who do you want to gather all the assets, pay the taxes, deal with the lawyers, deal with the accountants, and get the assets out to the people that are listed in the will, and who do you trust in that position so people aren't fighting over that. Also, if you have minor children, a will is important because that's where you nominate guardians to take care of them if something happens to you before they turn 18. And then obviously, I think I've mentioned this a lot, but a revocable trust is very useful in terms of avoiding probate. And it's not really, it's not restrictive in any way. So there's really no downside to it. And so I'd say those are essential estate planning tools that everybody should have and consider. And if you don't, you probably should, so that you don't end up in a situation where you're wasting money on legal fees, essentially. And that is all. Oh, here we go. Questions.
Okay, so we have a lot. You ready?
Yep, I think so.
Okay. So someone in my family told me of an elderly relative that set up an irrevocable trust for Medicaid planning protection from spend down of the property. However, due to the nature of the trust, she's stuck in her home and can't move into an assisted living facility where she would now be better suited. This seems to be a great pitfall of an irrevocable trust for Medicaid planning. Can you shed some light on this?
Yes, so irrevocable trusts are not for everyone, and they're not for every situation. So everyone, not everyone, but many people come into our office and say, I want an irrevocable trust, I want to protect my house, I want my kids to get it, I don't want the state to take it, put my house in a trust, I heard on the radio, that's what we're supposed to do. And it's not the case for everybody, because once you put it into an irrevocable trust, you cannot be the trustee, and you also cannot be the beneficiary of the equity in the home. So if the house is sold, the trustee cannot take the cash and pay for assisted living for you. You cannot get any of that cash out. That's the disadvantage. The advantage is that after you put it into an irrevocable trust, should you need a nursing home in the future, then there will be no lien on the property from Medicaid if you're eligible for Medicaid otherwise. So I would say every circumstance is different, and we evaluate lots of factors before we would do an irrevocable trust. Like, do they have enough money outside of this house to pay for assisted living, to cover for home care? There are mass health programs out there that pay for home care and that pay for assisted living. Just depends on the assisted living that they go to. It's not like a nursing home where every nursing home in the state takes mass health, so you don't have to go to certain ones. With assisted living, not every assisted living does take mass health, so it's less flexible. But yeah, so potentially they didn't evaluate maybe what she had outside of the home to make sure she would have enough in that circumstance, or she didn't understand. I'm not sure what happened, but definitely something that you need to have a long, in-depth conversation with your attorney about, and reviewing all of your assets before you do.
Sorry, I was muted. That's like the saying of 2020. I'm on mute. If a wife and husband transfer their real estate to a revocable trust, is that a taxable event like capital gain?
No.
Great, that was an easy one. Reality trusts are often used to protect the identity of the owner. Realty. Can a revocable trust do that also if you transfer the deed over?
Yes, so you could just, so realty trusts protect the identity owner because they might, usually a realty trust is called 172 Smith Street Trust or something like that. Doesn't have the person's name on it. And then the beneficiary who owns it isn't listed in the document that gets recorded. With a revocable trust, you could also have any title that you want. So you could call it the 211 Farm Street Revocable Trust or whatever. And that trust does not get recorded with the Registry of Deeds. So just a trustee certificate gets recorded to say who the trustees are. So I think that can be accomplished with a revocable trust.
And then this is a yes, no. Assets in an irrevocable trust are not taxed upon assets in assets in irrevocable trusts are not taxed upon death, correct? So
that depends on the estate plan. So sometimes, so anything in a revocable trust will be included in the gross estate for determining whether or not you have a taxable estate. For example, in Massachusetts, if it's over the million, or federally, if it's over the 11.7 million, revocable trust assets will be countable. And sometimes with an irrevocable trust, we're also drafting the trust so that they will be countable in the estate. And that just depends on the plan. And the reason that you might want to do that is if it's included in the estate, the beneficiaries who inherit it get a step up in basis at the date of death. So when they go to sell it, they don't pay tax on the capital gain. So sometimes it's more beneficial to pay the estate tax than it is to pay the capital gains tax, which is higher usually. So it just depends again on your plan and on the drafting of how your trust was drafted.
Okay. What estate tools are available for a $2 million IRA to avoid mass estate tax with no spouse?
That's a tough one because in order to gift it, you can gift it. In Massachusetts, there's no gift tax. And federally, you can gift up to $15,000 to as many people as you want without paying any gift tax, without filing a gift tax return. And you can give away more than that if you want to. You just have to file a gift tax return. And under the current law, there'll be no gift tax due up to that $11.7 million lifetime exclusion, which may change and probably will change with this administration, but that's the law today. But to reduce the IRA, you have to withdraw it, pay income tax on it, and then gift it. So you have to work with your financial planner and estate planner to figure out if it makes sense or not.
Okay. Let's see. I think they're a little off topic, but okay. We did that. Can a power of attorney be used to take action on a living trust if the primary trustee becomes incapacitated and the trust names a different successor trustee, not the person on the power of attorney?
The power of attorney will govern assets that are outside the trust. So typically those would be like an IRA or 401k, checking accounts. Whatever the trust owns, like your real estate or stock accounts or anything else you might have put into the trust, would be governed by the trustee. So if there's a successor trustee, that's who would be in charge of those assets. If there's a power of attorney and then a successor attorney in fact, that's who would be in charge of the assets outside of the trust. A lot of the time, people use the same person for that reason, so it's all consistent.
Okay, then how often should a couple over age 70 who have a will and revocable trust set up by M&B formally review the will and trust, and is there a fee for this?
Yeah, so I would say usually we say check in every 5 years or so, or if any of your circumstance changes, like if someone becomes sick or you think might need a nursing home or any type of diagnosis for illness or anything, just check in. We don't charge you to call us and ask us questions and just check in. So I'd recommend reaching out to the lawyer here who drafted your plan and just say, hey, is it appropriate for me to do a check-in? And I'd quickly look at the file. Everything is scanned in. It's really easy for us to access and say, no, it looks like this is the situation. You're probably all set. Or, hey, we still have questions about this and this or whatever. Just check in. We don't bill you for doing that. Would rather you do that than not and then have something be not tied up.
Okay. Can a POA be used to amend a revocable trust or to succeed grantor as trustee while grantor is living?
No. So, so the power of attorney, there's two types of powers of attorney. One is a general durable power of attorney, and one is a springing power of attorney. The first one is the one we do almost all of the time. And you are giving your attorney, in fact, broad authority to do anything like amend trusts, make gifts, change beneficiaries, and they have that authority before when you have capacity. So you do not have to be incapacitated in order for them to do that. That said, you also have the right to revoke your power of attorney. So if my husband, who's my power of attorney, signs a trust giving everything to his new girlfriend and not my kids, I would contest that and say, I have capacity, you can't do that, and I would revoke the power of attorney and change my estate plan back to what I want. So hopefully I think that answers the question. The bottom line is you should definitely trust the person you're nominating in that role.
Okay, who pays tax on the sale of assets from an irrevocable grantor trust while the grantor is living? An attorney told us the grantor pays.
Usually it depends. So there's all different types of trusts, and we draft them different ways depending on the circumstance. But if it's an irrevocable grantor trust, then the income tax is payable by the grantor.
Okay. And do lifetime gifts get included in mass taxable estate?
Yes, in a sense, they get brought back in, but it's still, you'd pay a lesser estate tax than you would have if you didn't make the gift. In most cases. Again, you need to check specifically with your situation with your lawyer to make sure this is general information and general answers. So you want to make sure you get your specific situation evaluated.
Okay. Setting up a UTMA for a young minor can impact their chances for full financial aid for college. Can the account be opened in the family trust to avoid that?
Yes. So you could create an irrevocable trust for education or something like that for your grandchildren and nominate a trustee and have that trust be fully discretionary for their education. That might be something to talk to your attorney about.
Okay, you're rolling. I've got a couple that come in through email too, but if a parent changes ownership of a 529 college fund to the adult child, do you feel a gift tax return should be filed if the residential value is over 15K?
So they're giving the 529 to their child. I don't know the answer to that. I don't even know. So in that case, you need to talk to the financial planner about the ramifications of doing that, because there's going to be penalties and things. If you're not using it for education, potentially you're just withdrawing it and making a gift. And if it's over 15,000, then technically you would need to file a federal gift tax return, even though no tax would be owed. But I'd say check with your financial planner and accountant.
Okay. All right. Let me go to the email. So, do I need a revocable trust to avoid probate if all my accounts have a designated beneficiary? And number two, I signed Fidelity's form confirming the beneficiary. That's one question. And then as far as non-monetary assets, jewelry, car, if I designate a durable power of attorney, the authority to distribute these things as specified in my will, can I avoid probate? And finally, do you think pooled trust for 65 plus as a vehicle to access cash for needs not covered by Medicaid will still be an option 5 to 10 years from now when I'm likely to fall apart and require Medicaid coverage?
So I guess, the first question is, if you have all of your assets, have a beneficiary listed, and you own nothing in your name alone with no beneficiary, then you don't have to go through probate. The second question, what was the second question?
Non-monetary assets, jewelry, car, if they have durable power of attorney.
Right, so durable power of attorney, their authority dies when you die. So that's no longer valid. Neither is your healthcare proxy, obviously not your healthcare proxy, you passed away, but your durable power of attorney no longer has authority. Now it's either a trustee or a personal representative under the will. And so if you have a car, what happens there is if it's under 25,000, actually I think now the new law says that a voluntary administration can be done for 25,000 or under plus any car. I don't think the car is included in that 25K. So you'd have a more limited, easier probate, the voluntary administration, in order to get that transferred. And then with the pool trust, I'm not sure. So right now you're allowed in the current law to transfer assets to the pool trust. We do that a lot for Medicaid planning. The assets can be there for your lifetime. The Commonwealth of Massachusetts has to be the first name beneficiary. The pool trust administrators, it takes their percentage. And right now that's a permissible transfer by Mass Health, but I don't know if that will always be, or if someone who created one will get grandfathered in, even if it's not anymore. So I don't know, but we will, we would certainly notify you if that changes through the e-letter that we put out.
Yeah. And so I think we're actually right about time. I know we didn't get everybody's questions, but don't worry, I will forward them on to Tricia, and we will cover what we weren't able to answer because we're right about up on time here. So thank you to all of you for attending. This was complicated and rich, and I think super helpful for me even to think about. If you have additional questions that come up as you're sort of processing all of this, you can send them to me, bck@margolisbloom.com. And I will send out a recording when it's available so you can review it. It usually takes me about a week to process everything. And then just additionally, what Tricia just mentioned, we do have an e-letter. I'm sure many of you found out about the webinar through the e-letter, but we do put a lot of information out there, including recently, Mass Health changes and things to be thinking about. So please do subscribe to that. You can subscribe on our website, and there is a ton of information and videos and all of our past webinars and podcasts. We have a lot of information so that you can help inform yourself, and then feel free to contact us to ask us more questions. So please do look at our website, margolisbloom.com. With that, thank you, Tricia, for everything. You did an awesome job. I feel like I learned a lot. So thank you so much for your time today. I appreciate it.
Good. And thanks everyone for coming. Have a great day.
Thanks, everyone.